Hi, I'm Max Dilendorf, a New York attorney and a real estate advisor. In today's video, I want to address one of the most common and expensive mistakes I see foreign investors make when purchasing U.S. real estate. And that is buying property through a U.S. limited liability company or LLC. At first glance, using an LLC may seem like a smart decision because it offers liability protection, a degree of privacy, and is commonly used in U.S. business transactions. But for non-U.S. residents, purchasing real estate through a limited liability company can actually create a serious tax exposure and legal complications that are often overlooked. Let me explain why. So first, let's talk about tax reporting and complexity. When a non-resident holds real estate through a limited liability company, they are required to file annual U.S. tax returns, often using IRS Form 1040-NR for reporting rental income or capital gains. And in some cases, the LLC may be treated as a U.S. trade or business, triggering what's known as a branch profits tax that can result in an additional 30% tax on repatriating profits. In contrast, owning the property directly as an individual may subject you only to the 15% further withholding upon sale, which is a much better outcome in many cases. Second, there is no gift tax advantage to using an LLC. So let's say you plan to give the property to your family member by transferring the LLC shares. The IRS will treat that transaction as a gift of U.S. situs real estate. And as a non-resident, you don't get the $14 million lifetime gift tax exemption that U.S. citizens enjoy. In fact, in 2025, you only receive a $19,000 annual exclusion. So for a $5 million property, the federal gift tax could exceed $1.9 million. The LLC does not shield you from this liability, it just adds complexity. Third, and perhaps most overlooked, is U.S. estate tax exposure. If non-resident passes away owning U.S. real estate through a LLC, the property remains within the U.S. taxable estate and is subject to U.S. tax jurisdiction. The IRS provides only a $60,000 exemption to non-residents, and the rest is taxed at rates up to 40%. So that means if you pass away owning a $5 million property through an LLC, your estate could face almost $2 million in federal estate taxes. Holding the title through LLC does not protect you against this tax, nor does it preserve confidentiality in a meaningful way. In fact, legal disputes can easily collapse the LLC structure, exposing ownership in court. There is also the matter of ongoing compliance and costs. LLCs require annual estate filings, payment of franchise taxes, and appointment of a U.S.-based registered agent. And these obligations add administrative burden and legal expense with no offsetting benefit in most cross-border real estate ownership scenarios. If you are a non-U.S. resident considering buying a property in the U.S., don't default to using a U.S. LLC company. It may seem like a convenient structure, but in most cases, it does more harm than good. Instead, work with legal and tax professionals who understand the nuances of international tax planning and can develop a structure tailored to your specific goals and country residency. The United States has tax treaties with more than 65 countries, many of which can play a critical role in properly structuring your real estate purchase to minimize tax exposure and preserve long-term flexibility. Thank you for watching. If you found this helpful, subscribe to the channel, for more legal insights on international real estate structuring, tax planning, and asset protection. I will see you in the next episode.